Thank you very much for being here today. And Carola, thank you for inviting me to come and speak about GDPR. So GDPR, for you who may not know what that is, it's General Data Protection Regulation that's being implemented and is going to come into force in May 2018. And it's going to have a fairly big impact on the way that we take care of business. So I do have to give the safety features that everything that I say is my own opinion. It's not the opinion of my employer, Opt-4. And with that, hopefully you have, if I say anything, you have questions, we can go through that later. So GDPR is what we're talking about, but e-privacy still is a rule that we have to take care of today. So e-privacy has a lot to do with the business that you're in today, as opposed to just GDPR. So I thought today we could start off with a quiz about your geography knowledge. Who here thinks that this was a picture of Prague? Raise your hand. No, not Prague. How about a really good Photoshop image? No? All right. It turns out it's actually south of Geneva, and the reason that this seemed to be a really good graphic is that e-privacy, the new regulation that's going to be coming into force, hasn't been finalized. So we're actually working on GDPR, but we have this mystery thing about e-privacy, and that's going to have an impact on over-the-top, like your WhatsApps and many of the things that we talked about and saw today. So as we go through this, I just want to make sure that we remember GDPR has some accompanying legislation that we have to keep in mind. All right, so what is GDPR about? So if you leave the room today and you go like, oh yeah, I was on the talk of GDPR, was the most boring part, just walk away remembering it's all about transparency. So we see that's a key theme, and what I really like is that the legislators, they wrote the law, they used 129, I did count these, 129 words to say essentially what you could say in about 6. Make it easy to read and easy to find. So that's what all that means, and so it's okay, you don't have to read it. So we do have in the UK, we have the ICO, which is the Information Commission's Office, and they're very good at giving us guidelines. The only thing is, because as I said, the e-privacy is just not really settled yet, so we have draft guidance. One of the things that you'll want to remember is documenting is everything. So with your consent, when you're interacting with the users, there's certain things you'll have to do, and you'll have to show that you actually did it. So that's one of the key changes that the ICO is saying that you should take care of. You have to make it as easy to get out of it as you made it to get in. Then the other things that they were saying is that you have to make it unbundled. So no longer can you bury the right to be marketed to in the fine print. You actually have to call it out. And that comes right into the active opt-in. So the active opt-in is where a pre-tick box is not going to work anymore. Now, this is the opportunity to go big. You can go big because you want people to say yes. So make your content and make the opt-ins big enough, and don't scare them. Say like, hey, you know, this is what we're doing. We're transparent. And we can talk a little bit more about some of that later in the talk. Granular, that's just essentially, people like choices, as we saw all day long. People want to have omni-channel, they want to be available, they want to know what they can say yes to. And probably the most important thing for the audience today, for you as brands and publishers, is the last bit. So can you sell your marketing lists? Can you sell your email lists? Can you sell your, I don't know if you even do mailing lists anymore by post, but if you do, you'll have to actually name the individuals, the companies that you want to share that with, and get the opt-in, unless it's by post. So post is a little bit less picky, but for everything that we're doing today, that we're talking about today, you have to make sure that you get the opt-in. And I'll show you a little bit more about that. So everything is changing. I think you heard that. It's changing in a great way. It's unfortunate because right now is when we have everything worked out. We're just about where we can do the multi-channel is going to go to omni-channel, and now comes in this really ugly law from Europe. So Are they trying to kill the internet? And a lot of people ask me that. Well, it has to do going back to the transparency aspect, where maybe in the past we were a little bit opaque about what we did with people's data. So it's coming back the other way and the pendulum's swinging, so that we now have to do a little bit more. And part of that little bit more, I want to focus on something a lot of people don't talk about, the impact on the database. So what does that mean? Can you, when you start giving a little bit more granular selections and options, and people opt in to just getting emails, or if they say, oh, I want only to see emails at the dinner hour and so forth, can you actually execute on that? Can you store it? And it goes back to the evidencing. So Carola made me promise I would keep this positive, so we're not going to talk about the enforcements and fines. So we'll move away from that, but if you have questions about that later, there are some reasons why GDPR is so popular. It's because people are paying attention. One of the challenges is that too much more, and I really mean too much more, is now personal information, and it sometimes defies logic, such as a device ID. So how can that be personal information? So it means if you can identify a person, a natural person, then it is now going to be personal data. And why is that important? Because the GDPR says it covers all personal data. So it gets a little bit complicated, and particularly I think in the Google context, where you have a particular ID for an individual and you're tracking them on the web, what is that going to mean? GDPR doesn't really talk about it. It's going to be in the new e-privacy regulation, which we don't really know what it's going to say. So I think Carola will have to do another session once that comes out. But are there any surprises here? So I'll say something about the fingerprints. A lot of us use our biometrics to log into things. And the reason it could be protected, or should be protected, including your voice, there are a lot of arguments to like, well, that's really not connected. But because it is, you now have to be concerned about video and other things that tie back to an individual. And so when I heard about the eye tracking, and that was Ipsos was doing something, I think, for Facebook, one of the past speakers, I thought, oh, so they were tracking where my eyes stand, and they're probably using my camera and my iPhone camera to do that. I said, I didn't give them permission to do that. So, you know, how does that feel? Does that feel like it's invasive? Are there any surprises? So those are the kinds of things as marketers, when you're putting your campaigns together, try not to surprise people in a negative way. Try to delight them. So keeping sort of that principle in mind. Now, this gets into some of the deeper parts of GDPR, but it's important for us to cover. So necessary for a contract, that's the easiest part. You can have a relationship with a contract. And I think a lot of you, once you have the customer, easy. Getting consent for direct marketing is a little bit harder, but you have to do it under current law today with regard to the e-privacy laws, at least in the UK. There are other places in the European Union. And then there's the US, which is you don't have to get consent. But your email and text today, you still have to get consent. So, and automated message calls, which I don't think is anything that you guys do here. Now, of the 6 lawful grounds, there's one that's still kind of interesting for us. It's called legitimate interests. So many of you probably have already heard about legitimate interests, but it's actually written in the text. So legitimate interests of the controller or a third party. So that's really helpful. Third party could be, you know, your partner in distributing and sending marketing. So we'll take a look at how you might be able to take advantage of that in just a second. So in the legitimate interest evaluation, you need to look at whether, again, we talked about surprises. We don't want to have any surprises because the reasonable expectation of the consumer is involved. And what we also want to do is ensure that we're e-privacy compliant. One of the things that the GDPR gives us out of the 173 recitals that explains the 99 articles in the 88 pages of the law of GDPR are 19 precious little words. And these words are, it's a legitimate interest of a data controller to have the ability to do direct marketing. And that's fantastic news. So it's saying in the GDPR, direct marketing with a legitimate interest is available to us. And so it's not as dire as you might think. The only problem with that is that once you do the analysis, you go like, oh yeah, but there's that e-privacy thing that's coming along. And e-privacy has to do with electronic communications. So in a way, what the GDPR giveth, the e-privacy taketh away, sadly to say. But let's see if there's another angle in GDPR that we can potentially leverage. A legitimate interest in profiling actually is also in the GDPR text, surprisingly. And so I thought, well, that's certainly helpful for us. It's saying, so all these fantastic things that we were saying about attribution to the omni-channel would fit in this bucket. So you have a legitimate interest in profiling in a direct marketing concept. There are some things you have to do, though. You can't just say, oh yeah, I have a legitimate interest, I'm going to just do omni-channel for European residents. You'll have to actually do an analysis. And within that analysis, you'll want to make sure that you have properly told people at the time that you got their data that you're going to be doing that. And that you also give them a chance not to have that done to them. So it's called the right to object. So at the time you collect, you want to say, okay, I'm doing this, and you don't have to have it done to you if you don't want to. But as long as you give them those two things, you can continue with your profiling. So as I was saying, you have to tell them that you're doing it. So one of the things that's super important to do is to take a look at your privacy notices that are going out, work with your legal team or whoever's in charge of that, and make sure that you have a legitimate interest for profiling for direct marketing included in that privacy notice, along with 15 or 20 other things you have to do. But I think that's really a helpful thing for this audience today to know that we can do that. And we were talking about the mailing lists as well earlier, and then sharing with third parties. Make sure that you name them rather than giving an indication of the categories. In the olden days, which we'll be calling the good old days, is that you would be able to say, oh, I'm going to be sharing your data with automotive clients, or it's going to be in this vertical. No longer can you do that. You actually have to say it's going to be with Ford, it's going to be with Waitrose, and so forth. And give them a chance to say no, depending on the way that you're going to market. And remember, the e-privacy deals with text and with email and potentially with over-the-top when it comes to, and over-the-top meaning of the WhatsApps and all the different things that we're used to now. Okay, now the big question that we all have, or at least I hope you all have, is whether you can use the data that you have in your databases today. And the answer is maybe. So, and maybe for good reason. Because if you already did everything transparently, then you have no issue. And the commission says, you know, if you meet the GDPR standards, you can go for it. If you're not so sure, then this is a golden time, a really great opportunity to get back into your database, take a look at what you have, do an inventory, figure out how you got the data, if you collected legitimately and fairly, if you can use it for just post, or if you can also use it for email marketing, and so different channels. And make sure it wasn't, if you got anything that was a pre-tick box, you know, opt in unless you untick, you can't use it come GDPR time. So this is, again, a really great time to take a look at what you have and consider doing a re-consent strategy. So what you want to do with that is more than likely take a look at all the journeys, all the touch points that you have. And we can talk further about this, but they're essentially, you need to make sure that whatever you said that you honor, and then you can start thinking about if you're going to do a direct, if you're going to do a mailing, because legitimate interest gives you the right, generally speaking, to mail anything you want. But since this is a modern age, we don't really want to be using mailing. Post. So make sure that if you're going to email, that you have the right consent. Now, if on your website today you have a registration for a newsletter and everything, start getting the ask. Go big and ask and say, these are the things we want to do. This is how long we're going to keep it, and take a look at our privacy notice, and you can opt out if you want to. And then you start having an inventory of usable data that you can use come May. And on that story is like, how do you ask for it? There are horror stories about opting in is a disaster, it will kill business, and that the opt-in rates are horrible. So I think it all has to do with making sure you get to the right people. Like those who've already unsubscribed, you can't ask them anyway. This is email. And you want to take, and maybe you should be testing some of your scripts. So this one particular actual script worked very well for some of our clients. And the results, as opposed to your standard between 35 and 45% opt-in rate, was actually 66%. So I'm hoping that gives you a ray of hope that even with GDPR being clouded by the e-privacy that's coming and that is here today, that you'll be able to do something with the data that you have on hand. And with that, I want to share with you that we have some resources that we recommend. The ICO I mentioned earlier is very good for UK businesses. There are other countries, if you do businesses in other countries in Europe, you'll want to take a look at their recommendations. And we also have on our website, which Data Protection Network is member-based, and it has a lot of tools and information that you can get from there. So with that,
before we go into questions, just got a couple of little bits from me. Just so everybody knows that we, Jellyfish Connect as a business, are working with Opt-4 to guide us, because obviously we collect data on your behalf. We send data across to you or to your fulfillment bureaus, so we need to make sure that we're doing everything correctly. So we're working with Opt-4, which is Karima's here, and the rest of the team are guiding us. But there's just a few things to think about. I think that certainly when I first started thinking about this, I was just thinking, okay, just got to think about this for our database, but it goes way beyond just the database. It's not just your subs database, it's not just your email database. Think about what you're actually doing with Google Analytics and where you're actually collecting that, because I know in many cases you have your own websites, but you're also working with third parties, you're working with fulfillment bureaus and others who are also collecting data on your behalf. Just check what they're doing. It goes a bit beyond. Everything might be fine, but make sure that's on your checklist of stuff to do. It's not just your own in-house database. Also, some of the things we talked about obviously before, email we use quite extensively now with doing online advertising, using it for customer audiences. Make sure, I think going forwards, it's all going to have to be, you can only upload that if somebody has explicitly said yes they can. Think about what you're doing, how you're doing it. I mentioned earlier, I'm actually going along to a Google event end of October, which is they're going to specifically talk about what they're doing and guide us in terms of what they are going to change, what's going to continue, whatnot, but they're under the same rules and regulations that we are. So there will be some changes, I'm sure, that are going to come up that will affect what we are able to do going forwards. And the other thing is obviously apps. We obviously work with a load of you guys on apps. We're having to look about this as well. It's not just about what you're doing in terms of collecting subscriptions. You're all collecting data in apps and you're asking permissions or not asking permissions or using that data in different ways. So it goes beyond just your subs data, your acquisitions and your subs database, just to think a bit broader. In your goodie bags, there is a little 10-step 10 steps towards compliance checklist that we've put together together with Opt-4, which hopefully will give you a little bit of a thinking and things that you need to be doing, sort of following you through that journey, which we thought might be useful. And as a business, we've actually got together with Opt-4. I'm well aware that there are some particularly smaller businesses out there that don't have big legal companies there to work with them, and we've got together, so if anybody actually needs any specific help, we've put together sort of a little sort of one-size-fits-all package, which we can do a morning workshop or afternoon workshop with particular people to help you identify where there may be issues, the things you need to do, put together an action plan, and then after that there'll be like a help desk support, so sorts of things, when you redraft your data collection statement, is that right? That sort of that ongoing support that's there. So if anybody is interested in that and would like to sort of take that up, either let me know or any of your sort of direct contacts in the client services. So time for a coffee break. Thank you, Karima. Thank you.